So now, Professor Dhanda, let me ask few questions about your writings. You have written so much that I need to do
Not
more.
so much, but still, I'm hoping to write more now.
Yeah. So let me, to begin with, ask you about this revising of N.S. Bindra's interpretation of statutes. You have virtually rewritten the book and
That's true.
reduced it, I think, to almost one third. So would you say that you have retained the essence of the author, original author, or is it a completely new book now?
Well, I would say I have, to some extent, kept his structure, but not really even that. Okay, I'll tell you. I mean, it was my deal with LexisNexis was that I will revise the book, but on this condition that they will let me throw out, not just add. And which is like the first time I spoke with them, they were not so very willing, but the second round, they allowed me to do it. I told them an interpretation book, which is only reiterating that canons of construction on a constant kind of basis, is helping nobody. It's a useless book. So for whatever reason, they decided to go along with me. And then the book did well in the market. So as a result of which, I was allowed to continue with what I'm doing, sort of things. And so what I landed up doing, Professor Mustafa, is that, very often, a lot of people believe that interpretation of statutes, even teachers who teach the course, believe they have to teach people the canons of construction. Whereas, actually speaking, interpretation is a part of an institutional structure. You have a legislature which makes laws with some kind of intention. You have an executive which implements it. And then you have the judiciary coming in. You can't really do interpretation without understanding the institutional structure. Because it's like if you are one of those judges who believes legislative intention is supreme, then the manner, which canons of construction you will use, will depend upon this factor of how you think of yourself as a judge, of the whole adjudication process, and the manner in which the legislation has been made. Then I can interpret exactly the same legislation with different kinds of approaches depending upon what's my philosophy and ideology as a judge, is something we don't teach our students. And unless you teach them that, you really cannot teach them interpretation.
Right.
So this book has kind of divided the book in that manner. There's a whole first section which is talking in terms of the whole legislative thing. The inner section is, the technical stuff, what you understand as canons of construction, and a whole new part has been added on the role of the judiciary, the theory of precedent, all of that, and how that weighs on in how interpretation happens. Good. So if you are a restraintivist judge, then you are not going to be, you're going to do interpretation very differently from an activist judge. And we need to be aware of it.
Okay. So, Professor Dhanda, of many articles you have written, including popular articles, I am reminded of one, and I said I would return to this whole insanity business in a minute. But before I go there, tell me about Justice Kernan's judgment and the order of the Supreme Court, which you said that it fails the test of both law as well as compassion. And then you say that the Supreme Court does not have the power to discipline High Court judges. So do you think that he was really, unfairly treated? Is there some kind of a presumption against Dalit judges? Because
I think it was very shabby.
Very, very strong article on this.
Yes, I did. I mean, I think it was very, very shabby. And at the time when I wrote it, it is like everybody came out in full-fledged support to the manner in which Prashant Bhushan was, dealt with by the court. Prashant Bhushan was amongst the people who had criticized Karnan, but Karnan came out in support of Prashant Bhushan. I'm just giving you one. It's like, and if this is not bhaichara-vad, so to say, or you're saying that because we are all in the same class, so it is one Supreme Court judge who is not comprehending what the rules of the club are. and Karnan was treated as the outsider. You have so many reports coming in from the Right to Education Act and the manner in which Dalit students, they deal when you're talking in terms of free education. The teacher tells them, you sit outside the class, you go clean the toilets, you clean the utensils, you do this, that, and the other, but doesn't let him study. And Karnan, in some of his testimonies, had spoken in terms of a upper caste judge literally putting his shoe at his face, sitting in that manner. And so we have to recognize that, that the kind of very subtle and not so subtle discrimination which subsists. You look at the way in which invitations are handed out by judges. How many Dalit judges get invited for the various inner social events of other judges? And to say that this doesn't impact upon a person, come on. So I'm saying is, if you are not aware of your own privilege, if you're not aware to say, oh, I don't see caste. Of course you don't see caste, because you don't have to see it. Only the person who is being discriminated on that ground, only the person who is being all of the time excluded on that ground, that's the person who's going to see caste. To say that just because they say that they did not see caste in how they saw Karnan doesn't exonerate them. I'm sorry. I mean, it's the same set of judges who say justice is not only to be done, but should be seen to be done.
So you see in agreement with Indra Jai Singh that since power of discipline is not there with the Supreme Court,
yes, I am.
So what Supreme Court cannot do directly, it can't do through contempt of court powers.
Absolutely. But you
had who is saying that the passports of Supreme Court judges should be impounded. He also went too far.
Maybe. See, the thing is that if you are unhappy, it's the same kind of thing, no, Professor Mustafa, like look at the farmers' protest, that you protest for peacefully for this many months and nothing happens. Then you let people in and it goes, you forget all of that peacefulness and that one thing, because the entire burden of staying peaceful is on the person who's protesting. There is no obligation on the government if your people are protesting in such large numbers. Why have you not been able to do anything? I mean, the same thing happened in the Shaheen Bagh case. I'm putting the same point. I am not willing to put. If you look at the power dynamics, the power is with the Supreme Court, not with that single High Court judge. If he's not being listened to and he's talking ordinary bhasha, and then you pick up on the stuff that is evidently maybe it's not on, why is all the burden on the person who is dissenting? Or the person who's being badly treated? That you must in all cases behave well, but we can treat you as we please. That's where I come from.
Yeah, you have also talked about medical examination of a sitting judge aimed at disciplining him. And then you say that insanity as such has been routinely used as an instrument of social control, especially against socially disadvantaged. So can you elaborate it? What do you really mean?
See, when you look at, when you call somebody either mentally ill or insane, it's not like the same as when you say that someone has typhoid or somebody has tuberculosis. It's not something for which you can, like you can have a blood test or you can put a thermometer and you can find out what's the person's situation or condition like. So how do you decide whether a person is mentally ill or not? It's primarily on the sense of their behavior, what they do. So therein you go back to that if I have in my book, Legal Order, Mental Disorder, there's a whole chapter on matrimonial law, and it talks in terms of the grounds at which women, like divorce petitions are filed against women on grounds of insanity. So what are the kinds of allegations that are being made? That she was not respectful to my parents, that, she refused to consummate the marriage. She was much too forward with strangers. It's a whole range of stereotypes that you have on how a woman should behave. And the moment you go out of line, one of the consequences can be, depending upon, like exactly how you do what you do, that you could be called of unsound mind. Similarly, it is like a Dalit judge. I know I've had people saying, oh, he would like, he just wanted that he should be given bail. His docket should have been the bail docket because that's where lots of money is made. So you make allegations of corruption, you make all of those kinds of allegations. If corruption is happening with an upper caste judge, no problem. But if you are a Dalit, how dare you? Then one of the ways in which you handle it is, one is like you can say you can criminalize the person, you can put them away, you can throw them out of job on disciplining grounds. A third one, which as such gets a lot of social support. When you divorce your wife because she is mentally ill, and when you divorce your wife for any other reason, when you divorce your wife when she is mentally ill, the kind of social support you get, because what else can you expect the man to do if she is mentally ill? That's the reason why it becomes a big instrument of social control.
Yeah. You have, in the book, you talked about legal order and mental disorder published by Sage, and also in your article, Insanity, Gender and Law, Indian Contribution to Sociology, you raised these issues. So come to your another, writing about this passive euthanasia bill, and there you made a very interesting statement. When plug is to be pulled, is it the person, family, doctor, or the court? And then you say that we should learn to let go, but a loved one needs to leave. We realize that, but should holding of hands not precede the opening of palm? Very powerful, very emotional statement. But the way our society is, I think we are far, far away from what you want from your society.
Well, I think all of us have the right to dream, Professor Mustafa. And I think some of us need to constantly talk about what we think is not just doable, but what we think is where we should head. A large amount of my writing is on what I believe in. And whenever I get the chance, I try to do it. There's an article I'm proposing to write, which I'm calling Doing Administrative Law. I want to sort of, capture my 8 years of academic administration in trying to say that these are not things which are, out there. They are there in how you decide on things. And I suppose my one anxiety in the whole realm of euthanasia is this, that after all, who are the people for whom euthanasia is going to become the big issue? It's like, I've always had this position that in India, I don't need a right to die. I get it from birth. So to talk about euthanasia in a poor country, wherein, like hundreds of people dying doesn't bother us, we need to be very, very careful. We can't be guided by the West in how we talk about euthanasia. In their country, it's the insurance companies which don't allow the plug to be pulled off. So they need to talk about it very differently. In our country, we don't have the insurance to get that treatment. And you have an organ transplantation law. And you connect the two up and you speak in terms of that you want to do euthanasia in a poor country where you have organ transplantation. Who is the one who's going to get declared, is going to be declared brain dead? You can't talk about law absent its social, political, economic context. That's what I'm trying to say in different ways, kinds of things.
And then in another piece on Professor G. N. Saibaba, you wrote an excellent piece. How do you look at this case? Here is someone with 90% disability, of course, alleged to have links with CPI Maoists, but all kinds of people get bail. It was very difficult for him to get bail.
Yes, and then they cancelled it.
Yeah. What does it show about the health of our criminal justice system?
I don't know, I don't remember who said it, but it has been somewhere said that one of the ways in which you can be looking at the health of a criminal justice system is how it treats its most disadvantaged members. And in Saibaba's case, I would say that this is just torture. To talk in terms of you. I mean, it's a similar kind of thing that we did for Stanley's, where his straw did not reach him for the longest time. He could not really drink, because that particular straw is all that he needs. How is that any kind of a, dangerous instrument that you can't let it be with him? And can't you have it checked out in 24 hours or few hours or
Ask
whatever?
the government council, do you have any objection? Next,
that's what I'm saying is
hold a hearing on it.
You bend backwards about it's like if we say that enforcement of law and order, enforcement of discipline is the same as who can practice the most cruelty, then I would much rather have a lifetime reputation of somebody who broke discipline. Honestly, it's horrible. And it's like, okay, fine. If I'm saying, okay, let's go to the extreme and say he has those connections. Darn it, what is your entire other surveillance doing? You do that. Who's stopping you? After all, if you want to be, is enforcement of law and order only about locking people up and throwing away the key?
And
if this is how we should be treating our people,
Saibaba, even this Western toilet.
Exactly, so that's why I'm saying his treatment is nothing other than torture. I will not call it anything else.
So, Professor Dhanda, we are coming towards the end of our conversation. Now, you have to be congratulated on your retirement, because retirement is very good. That someone is closing one innings, you are starting another innings at Nalsar. You would be a professor emeritus leading Nalsar in research. So what is your plan in terms of making Nalsar a great destination of legal researchers?
I started my career as a researcher. And to that extent, I will always say that research is my first love. I mean, I really enjoyed my teaching. But research is my first love. But one of the things which I have found over the years is that whilst everybody is encouraged to research and write, we are not really guided on how to do it. Nobody kinds of tells you. If you are lucky and you have a good teacher who takes that trouble, then good. If you don't, and if you're not that lucky, then you just stumble around, and now with us, with the UGC making PhD compulsory for an entry-level position as a teacher, you're going to have all manner of people putting out very, very mediocre stuff if we don't take things into hand. I at least want that Nalsar becomes a place where we don't just demand things from people, we help them doing it. So that's one of the things that is on my agenda as far as our whole PhD program. The other is basically to also, in all Western countries, and that's some of the good things that one finds in, there is this certain amount of, where you allow for time off from teaching. You're not giving somebody a sabbatical or a study leave. You are just saying you can have a non-teaching semester. You're not teaching, but you can research, and this is the kind of output that we
already do it.
We have it basically for PhDs, that when you are doing your PhD, we will give you a non-teaching semester. That's also because we can't give that length of study leave that traditional universities can give. So we are doing something in between. But to do it as such, for everybody, that you can say after 6 semesters, you can take 1 semester off in which you are not taking, you're not on leave, but you're not teaching. And I'm sort of saying it, like I in my own experience at the Law Institute, we found that we were required to research on an all the time basis. That's equally tiring. So teaching has a way of rejuvenating you. if you are doing research, and research has a way of allowing you to replenish if you are teaching. So that would be something I would want to work on to try to create,
As
like
far as I
protocols by
remember,
which one
you've
can.
already incorporated it in the service regulations that even those who are not doing PhD have done their PhD. If they had a heavy workload for 3 semesters, then the fourth semester they can take teaching off. It's, I think we have made that rule.
I'll have another look at it, but I mean, and this is just the other, of course, was to try to create Nalsar as a destination for people from all over the country and outside to come and do their research here. Like to do it very proactively, invite people to have to come in here, because I feel collegiality and a lot of people doing research. It's like खरबूजा खरबूजा को देख के रंग पकड़ता है kind of stuff. Like you try to create that environment that if more and more people are writing and more and people are talking about what is needed, what needs to be researched and talked of, that's the other this thing. So, I mean, I'm just saying is these are like in terms of environment creation, have mentoring, help people, not just at the PhD level, because sometimes if you did a PhD, but you did a PhD with no guidance whatsoever, you may have done the PhD, but you really haven't learned anything in terms of research. So to accept the fact that this is a lack and it should be provided in a manner which is respectful would be something that I'm kind of keen on. Then we have so many centers at Nalsar. So to create some kind of an overarching research policy where, like you don't just let the centers thing, but some external impetus where people are being asked that, okay, this is our larger research policy at Nalsar. How is your center going to contribute there? More try to create convergences between the various centers and bring a certain amount of external impetus to do that. That's another thought that I have there. And to do like, say, again, we had in a couple of years back, we had this a special school that we had done for people who apply, who come in from the affirmative action quota and who apply for PhD at Nalsar, to do, like advanced mentoring for them, just to help them to formulate their own proposals in a better way kind of stuff. We have a winter school we do for disability, to see that if we can do something analogous for other areas and other centers, wherever we have strengths in terms of competencies. It's like just to create so much of a buzz in the place that research becomes the happening thing at Nalsar.
So since you are one of the founders of Nalsar and have played leading role in making whatever Nalsar is today, how do you rate Nalsar in comparison to other law schools?
We are good. We are good. I think we are one of the few institutions which has learned from its past. And possibly because some of us were on the rough end of the stick. So that memory existed of like the rough end. And a lot of is informed how Nalsar has reinvented itself. And I definitely do hope that, I mean, if I was to think I do hope that amongst the things that will stay on in Nalsar is that this is a place which can make mistakes, but which believes in learning from it. And it doesn't think that you're always right, and can learn from anybody. If you can create that environment, I think that is what largely becomes difficult in this very rat race kind of, 1, 2, 3 kind of nonsense that happens, where you don't do enough reflection. You don't have to look at other people. You have to be your best version. I think somewhere Nalsar has at least tried to go that route. And in some measure, not totally, lots and lots of things still have to be done, but we have moved.
All right. Since you referred to UGC, let me ask you the last question. Now, BCI is saying that they want to take over PG in law, LLM education. So why all national law universities are so UG centric? They are VC centric and they are UG centric. So what can be done in NLUs in improving LLM program?
Well, we have tried to some extent, Professor Mustafa, at Nalsar. One of the things that we did, of course, is that, and I'm sort of not saying that we have all the answers, but that it is possible, that's one route, is instead of like trying to make them two separate things, that we've created certain convergences between the UG and the PG program in how we run our elective courses and stuff. Because basically the reason why they are UG centric is that you have, one batch of students who are there for 5 years, and the others who are there for 1, max 2. So just the fact of that, like the PG, the turnover is so high, they really cannot contribute in the same manner in the design of an institution unless the institution weaves them into the design. That's amongst one of the big things I feel is important. Like we give teaching assistantships to our LLM students. We have them involved in all our elective courses. The elective courses are as much on offer for them as they are offered for the senior LLB classes sort of things, courses. The other thing, I'm definitely the BCI, I would very, very strongly oppose their taking over. It's like, you ruin undergrad education or you ruin postgrad also. That's the way I would see it. It's not... irrespective of how lawyers may see themselves, and I don't say there are not learned lawyers, but the learned lawyers are not the ones who are personing the BCI. So it's important that, because any election system is going to have that situation. It's that learned lawyer is not going to stand for election and is not going to lobby for votes and is not going to do certain kinds of things. So then who is going to be looking at this education which comes at the end of it? I also do think that if we did some much more of that's something amongst the things that I would want us to look more closely at Nalsar is to do just as we have a connection with the UG and the PG in terms of the teaching program, we need to have a connection between the PG and the PhD in terms of the research program. So, like what you're doing in your dissertation and how you are working on that to kind of like gently guide people towards doing deeper research. I've given you my own example that what I did as my dissertation then grew into my PhD program. I definitely do think that, this is a direction in which we can push people. And if you start to create a cohort of people who are on campus because they are passionate about research, then that research community itself will help in enlivening the PhD program. Attention is good for everybody.
Yeah. So thank you very much, Professor Dhanda, for finding time for us. I'm sure your association with Nalsar, now it's a lifelong association. You will never retire. You will continue to lead us in research. All the very best for your future endeavors and your health. I think you should take a break for a while on 31st.
I'm going on a retreat, Professor Mustafa.
You must.
I'm taking a 1-month retreat I really feel I need it. So I'm planning for it and I'm going.
Yeah.
And I also want to take this opportunity of not just thanking you and my colleagues for being there. I mean, in the last years that we have done so many things at Nalsar, so many of them have really, really supported me. So I want to take this opportunity to thank them. But most of all, I want to thank my students. I really the website you mentioned at the beginning of the program has been one of my most overwhelming experiences. And if I had maybe any regrets ever, I think they all vanished with that website. I felt that if I can earn this, I don't need to regret anything.
True.
Thank you so very much. Thank you for this opportunity, and thank you for being able to, to talk about things that very often one doesn't.
Right. Thank you so much.
Bye.